The Honourable Thomas M. Davis, Justice of the Quebec Superior Court. And it's a pleasure to have you here, sir. From 1983 to 2011, Mr. Davis was a lawyer with Borden Ladner Gervais, who barristers and solicitors, as they say, here in Montreal. From 2001 until 2011, he was a lecturer in employment law at the Faculty of Law at McGill University. He was appointed as a judge of the Quebec Superior Court in 2011. And if I'm not mistaken, he is currently a case manager for several matters before the court, including land claims by the Innu First Nation over territory in the Nestassinan region of Quebec. So I would imagine that you're very familiar with the situation with Indigenous peoples in Quebec and in Canada. He has been the chairman of the board of the Salvation Army Catherine Booth Hospital. He's been chairman and a member of the board of the MAB and the Mackay Rehabilitation Center, all in our area. And also he worked as the chair of the Salvation Army Advisory Board for Montreal. He is co-author of 2 books, the first one being La Nouvelle Loi sur les normes du travail. Now there's a real barn burner, I'll tell you. But I've been working in real estate. I've been through certain portions of that treatise, and there's a lot of stuff in there. And the Solutions for the Canadian Workplace is the other book that he has written. So I welcome, please, Thomas M. Davis. And sir, we're delighted to have you here. I'm going to give you the floor. Take your time. For those of you who have questions, don't be afraid to put them into the chat room, either to all of us, put it into all of us, and we'll make sure that they get asked at the end of the session. The floor is yours.
Yes, sure. I'd be happy to answer questions at the end. Thank you for that introduction, Jim. Appreciate it. So I don't actually have really a prepared text, so I'm going to extemporize quite a bit. And I thought I'd start off just giving you a very brief introduction of what the Superior Court does. There really are several courts in Quebec that some of you may have had the pleasure of going to. I heard, was it your 4 truths that I heard at the beginning? I think the court system is somewhat like that, save for the fun part probably. But so starting from the bottom and working your way up, there's the municipal court, which will hear parking offenses and minor criminal offenses. And happily, that means that our court does not have to do parking tickets. There's the Court of Quebec, which used to be called the Provincial Court. And without going into the exact definition, it's essentially any civil matter under $85,000. That includes a small claims division of the Quebec court, which I think is $15,000 and less. And those judges are named by the provincial government. And then there is the Superior Court, which, and this is a quote from the Code of Civil Procedure. The Superior Court is a court of original general jurisdiction. It has jurisdiction in first instance to hear and determine any application not formally and exclusively signed by law to another court or to an adjudicative body. And that adjudicative body reference is quite interesting because there are many tribunals in Quebec. The ones that you might have had experience with would be what is now called, it used to be called the Quebec Labor Relations Board. It's now, and there was the Commission des lésions professionnelles for work accidents. And those now are all part of what is called the Tribunal Administratif du Travail. And there are many other administrative tribunals. The rental board would be one. I could think of off the top of my head. There used to be a separate board for protection of agricultural land, which is now part of the Administrative Tribunal of Quebec. And all of those tribunals are subject to the to the general power of judicial review that the Superior Court has. So if you take a matter before the Administrative Labor Tribunal, for example, and you believe that that tribunal in rendering its decision has adjudicated beyond its competence or has adjudicated in an unreasonable manner, then you can take a judicial review application to my court. And then above my court is the Quebec Court of Appeal, which hears appeals from my judgments when people think that I have not judged correctly, or other judges too, of course. And that court can also hear certain appeals from the Court of Quebec, and then the ultimate court is the Supreme Court of Canada, which sits with 9 judges in Ottawa, and 9 judges from across the country, although Quebec has 3 according to the Constitution, because of the difference between the civil law and the common law, which is in the rest of the country. The Quebec, the Supreme Court of Canada has 3 Quebec judges, including the current chief, Richard Wagner, who actually was on our court still in 2011 when I started, I believe, for a very brief time before he went to the Court of Appeal. So that's kind of the general structure of the court system, and the Superior Court and the Quebec Court of Appeal and the Supreme Court of Canada are all named, the judges are all named by the federal, the Prime Minister, really. It's a bit more sophisticated than that, but the buck really stops there, and the nominations are ultimately approved by the Governor General. So I thought the best way to sort of give you a flavor of what we do is I'll just give you maybe some of the highlights from the month of April 2021, April of this past month, of stuff that I have done, and that will give you a pretty good idea of what our court does on a day-to-day basis. So we just to preface that, we basically hear civil matters over $85,000, all family matters except for adoption cases and youth protection, which is part of the Quebec court, bankruptcy, a special part of the court, any injunctive relief, and criminal jury trials. And I have, over the years, done all of those things except bankruptcy, which I have no desire to do, and no criminal jury trial. Those are really specialized judges that do those. Although someday, maybe before I retire, I might try to work my way into a criminal jury trial. So April 1st. April 1st, I found myself in downtown Joliet. So I'm not sure that is the highlight of the month, but it's illustrative of the we're an itinerant court. So while my office is in the big courthouse on St. Antoine Street, I can be asked to travel around the province to well, not all the province. What is those jurisdictions that are within the appeal district of appeal cases that are heard in Montreal? So Joliet is one of them. We go to Drummondville, Saint-Hyacinthe, Valleyfield, Saint Jerome, Longueuil, Saint-Jean, Richelieu, and so on. So my recollection of that day in Joliet is I heard a family case, and we do hear a lot of family cases when we're in the regions because there are probably less regular civil cases that proceed. So we hear a lot of family cases when we're in the regions, and a couple of other civil matters involving civil procedure. Somebody who missed the delay that wanted the delay to be extended because the person who should have advised the company about this legal procedure being served was working on télétravail, and she happened to be in the office that day and filed the thing and forgot about it. Anyway, I have signed that and sent that judgment, so I did relieve them from the default. And so for the rest of the month, I've heard a wide range of varied cases. I just decided it's a case, a class action case involving a settlement with the provincial government of a class action where the conduct that was being contested was, and it has long since ceased, by the way, but involved strip searches in I believe, provincial jails. So there was a settlement compensating some of the victims of that practice, and my role when I took on the file was to approve the settlement, make sure it was fair, and make sure the method that the parties had determined to ensure the distribution of the settlement funds and to ensure the publication or the publicity around the settlement was adequate. So that was one of the cases I've done in April. Then I've been asked by the Associate Chief Justice to be the case manager in a somewhat complicated divorce matter involving one party who lives here in Quebec, one party who lives in Switzerland. And there are a lot of issues as to whether the Quebec court should have jurisdiction over the matter or the Swiss courts, and how the proceedings should be served to the individual in Switzerland according to the Hague Convention on International Service. So that is actually quite a challenging case. And I would say that family law is can at times be the most challenging part of what we do. We are called upon to, for example, in a typical family matter, we'll be called upon if there are children involved to decide which parent should have or both. Often it's both, happily. But if there's a dispute, which parent should have, it's not called custody anymore, but which parent should be the primary caregiver to the children, where the children should reside primarily. And as I say, it's often joint residence between both parents. And I think family law is sometimes we see the best of people, but sometimes we see the worst as well. And that's understandable in a sense, because people are going through a difficult time. But sometimes you wonder whether the resources that are being used in a family matter couldn't be better spent on the children, for example. And sometimes you see cultural issues as well that come up, where people of different cultures perhaps marry here, or perhaps have married elsewhere, and have difficulty in terms of adapting to the realities of Quebec. One example, it was very early on in my career as a judge. It was a family case where the couple had not been married for very long at all. Had actually met in a foreign country. One of the parties was a resident here. That the husband was a resident here. The wife was a resident in a foreign country, where they were married, and the wife obtained her immigration papers with little assistance from her new husband, I might add, and flew over here, told him she was coming, but he never even picked her up at the airport. So it was quite a sad thing. So they actually never cohabited once she moved here to Quebec. Although she was quite a well-educated young woman, so I have no way of knowing, but I suspect she ultimately succeeded. But those are tough cases for sure. And then I am the case manager for a lawsuit where several suppliers in the aeronautics industry are suing Bombardier and Learjet over the cancellation of a program, a plane that was in the conception stage and was ultimately canceled. And the suppliers are taking the position, rightly or wrongly, that the reason that Bombardier raised for the cancellation of the program is not the real reason that Bombardier decided not to go forward. And so there's quite a large sum of money involved, and that case, all the contracts are basically are very similar and contain the same cancellation provisions. So it's been decided that all the cases together, at least on the issue of whether the cancellation provision that was invoked by Bombardier was validly used. And that will be probably a 20 or 25-day trial. And then depending on what I decide, the other ones will be heard by individual judges just on the question of damages if I were to decide that Bombardier's reason for canceling the contract was not valid. And then I am also the case manager for what I might refer to as COVID-19 meets business interruption insurance for dentists. So it seems that most of the insurers have refused to provide business interruption insurance to dental clinics that were required to close in March of 2020 because of the government decree, following the pandemic. And it's quite, so I have 3 separate files, which I heard all of them together over 3 days, the week before last. And so it's at the authorization stage of a class action. So what does that mean? A class action needs to be authorized by the courts of Quebec. It's the same, I think, elsewhere in Canada too, but the threshold in Quebec to have a class action authorized is, some people would say, is quite low. So basically the plaintiffs have to demonstrate an arguable case, or that they're the legal syllogism that they're trying to raise is not simply frivolous. And this will be interesting because 3 separate cases. In one of them, it certainly has been argued that the insurance policy is very different than the insurance policy in the other cases. So I'll have to decide in the next couple of months whether these dental clinics have an arguable case that their insurance coverage in the context of the pandemic and in the context of the fact that they were really required to close because of a government decree, and in fact they were able to stay open to do emergency procedures. So whether in those circumstances their insurance policies, they have an arguable case that their insurance policies allow for business interruption insurance. And then last week I heard, I didn't actually hear it on the merits, but it was another case where I'm case manager, and this one involves, in fact, 2 separate matters. One of them in the district of Joliette, and the other one in the district of La Belle, which is sort of the Mont-Laurier area, where the Quebec government has served proceedings on various individuals, asking them to dismantle and remove small chalets that they have constructed on government land. So at first blush, it would seem to be a very simple case, as long as the Quebec government could demonstrate that the land actually belonged to them. But the owners of these chalets have defended their action on the basis of indigenous rights as Métis. So they argue that their indigenous hunting and fishing rights as Métis allow them to construct these chalets and occupy this land. And that's kind of the same issue as the one that Jim referred to at the beginning, the Nitassinan land claim of the Innu, which is over a much larger area. And I'll be hearing them shortly on an issue involving that case started off with the contestation of the construction of the Romaine hydro project. And that's a run-of-river project. So it's a bit different from some of the other ones because there's no big reservoirs that, as I understand it. But there are a number of dams that were constructed on the Romaine River. The Innu take the position that they were not properly consulted, and essentially, I'm oversimplifying, but that this construction was not done in accordance with their indigenous rights or their indigenous title to the land. That case was ultimately the object of a settlement, but it now appears that it might actually be continuing in some other form. And the Métis case, they're arguing indigenous rights, as I said, and so there's a degree of similarity. So if this when this case proceeds to the merits, the Métis case, they essentially have to show that there has been a degree of continuous, not it's nuanced, but a degree of continuous use of this land for hunting and fishing since their contact with the first Europeans. So it's a very difficult process, and that has led to there's been a huge evolution of Indigenous law in the last 20 years in Canada, or the last 25 years, I guess. And the sort of one of the landmark cases is a case called the Haida Nation, which is a case out of British Columbia. And again, oversimplifying, but where the Supreme Court of Canada said that the honor of the Crown requires that before it authorizes projects on land over which a First Nations or Indigenous group has a prima facie right, has a duty to consult the First Nation on the project and possibly to provide accommodation as the project goes forward. And the degree of consultation and perhaps the degree of accommodation will also depend on, how strong the prima facie right is. Because there's been really one case, maybe, I think only one, the Chilkat Nation in British Columbia, where an indigenous title has actually been recognized. And that will be a case that, so the one of the Nitassinan ones that is actively going on right now is involving the hydro line from the Romaine project to the Alouette aluminum plant in Sept-Îles. And I'll be hearing them this September on whether the consultation that was carried out by the Quebec government was sufficient, and whether the accommodations that were offered were sufficient. So that will be interesting. And then after this meeting tonight, I will probably try to knock off a little judgment, very important for the person involved. One of the other things that we do that is very difficult, not difficult from a legal standpoint, difficult from a personal standpoint, is when a hospital needs to provide care to a patient, and it's usually in situations of psychiatric care. Could be either pharmacological care that they want to give, or in this case I heard today it was electroconvulsive therapy. And when the patient refuses that care, we have to decide whether or not the care should be given based on a series of criteria, including whether there has been a categorical refusal to the care. But the most important thing we have to decide usually is whether the individual has the capacity to consent or not. So it's quite difficult because you see people again who are sometimes in quite a crisis in their health, and we always have expert medical testimony, but it's still sometimes a difficult thing to decide upon, because the hospital wants to go forward and the individual does not want to go forward, and you're the one who has to be the arbiter of that finally. So that I guess I've gone on long enough. That is kind of the typical sort of month that I would do. And the typical sort of cases that I would and my colleagues would be called upon to do, although there aren't that many of us that do, for example, Indigenous land claims, because it's quite complicated. But that would be kind of if you look at the family law and then the commercial matter with Bombardier, and there's only a few of us that do the class action authorizations, but yeah, so there you go. So now I'd be happy to answer questions.
Okay, I've got a few of them here. I'm going to leave some of them out because I can, and there was one from me even. There's a couple here that are like obviously from a personal point of view, and I'm not going to bother with those ones. We're going to try and keep it as general as possible. So the first one I'm going to ask you is, how frequent are appeals? But like, what percent of judgments
of my cases or of other?
Or in general, yeah. In general.
Well, I will say that my judgment's not very frequent. I really don't know. Probably too frequent.
A lot of frivolous ones?
Well, so the Court of Appeal can throw out a frivolous appeal if it believes it to be frivolous. Jim, I honestly do not know how frequent they are. I believe they're probably a bit more frequent in Quebec than elsewhere. And I know I've heard the former Chief Justice Nicole Duval-Hessler speak on this topic. And I do believe that the Quebec Court of Appeal is perhaps the busiest in Canada. So it's fairly frequent, but I can't give you a percentage on really on how often it happens. I don't really know.
And I would expect that we might be a little bit more in the other provinces because we're a little bit more socialistic in nature, I think. So I can see
I
the courts maybe.
don't have any comment on that.
Okay, and away we go. Typically, how many cases would you have before you at one time?
You mean
you're juggling a whole bunch of cases at once, I would think.
Well, it's actually very variable. So when I actually, I probably have, at any given time, I probably have 4, 5, 6. I try not to have more than that, judgments that I might be working on, right? If I'm sitting this week, I'm sitting in a room where I'm actually in charge of all the cases that come through that room. So today I probably heard 5 different cases, of which I decided I think 2 or 3, and the other 2 are under advisement, but I'll render judgment this week probably. If I am sometimes in a place like say Sorel or Valleyfield, where the court doesn't sit every day like we do here, and I happen to be the senior judge, I may hear up to 20 cases in the same day. And when I say that, it's usually in family law matters where the parties would be asking for an urgent decision on a very specific thing, where we don't actually hear witnesses. We do it on the basis of solemn declarations. So I could hear, and some of them are by consent, and so I could, on a day like that, I could hear 20 different things. But when I actually, for example, when I sit down and hear the Bombardier case, and I think that's been scheduled for January of 2022 or 23, I'll only be doing that. I'll only be doing that for 20 days, right? And if the Natassinan case ever actually proceeds beyond the preliminary stage and is heard on the merits, some of those cases go on for 300 days, and those 300 days would probably be heard over 3 years or so, because typically the ratio is we sit 110 days during the year, and the rest of the time we're deliberating, writing judgments, or managing the files that we have particular case management over.
There's a question here, which I think you've already, you haven't actually said the amount or anything, but I think you've already answered it. It could be anything. And the question was, from the time the papers are filed to commence a trial in the Superior Court to its conclusion, what is the average time? And I think this can be, you can decide something in 22 minutes, or you might be there for 3 years.
Well, I'm not sure that, I don't know I don't know if the question is how long it takes from the time of institution of the proceeding until we actually hear it. That's going to vary on a lot of things, right? The nature of the case. So cases that involve individuals, we generally try to prioritize those cases so they're heard more quickly. The fewer days of trial, probably the more quickly a case will be heard. Family matters will generally be heard more quickly as well. But I mean, a very simple civil case, and I'm not fully certain of the delays right now. It's more the job of the chief. But I think a simple civil case could probably be heard in a year and a half. But a lot of the delay. Well, I shouldn't say it that way, but a lot of the time that it takes for a case to actually be heard depends on how the parties have conducted themselves through the whole time before the case actually gets to us, right?
Yeah.
So technically, from the time the case is deposited into court to the time it's ready for trial, there's a sort of a non-binding delay of 6 months. The parties can ask for that delay to be extended. So we try to encourage the parties to go as quickly as possible, but sometimes it's not always possible for them to do that. But the horror stories of 15 years ago as to how long it would take cases to be heard, that's not reality anymore. Cases are actually heard pretty quickly in the big picture.
Okay, thank you. There's a whole bunch of other questions here, but we are running late. So I'm going to take one maybe a little bit more personal for you. And that is, what journey brought you to here? Did you always want to be a judge, or did somebody convince you to be a judge? Do you like playing God?
Well, I actually don't think we.
That's rude, I know.
Yeah. No, I don't. So it's a good question. So I had practiced, and I sort of, this is kind of, it is somewhat ironic because our son is about to begin a career as a lawyer. So, but I've been practicing, I guess, for about 25 odd years when I sort of said, there is not a lot that I'm doing that I have not done before. Because I was in a pretty limited practice area. Those 2 books that I wrote will give it away, but I was doing employment and labor law. And, after 22, 23 years, there wasn't a lot that really tweaked my interest. Except a lot of the charitable stuff I was doing, which I had to give up. That was kind of too bad, but I enjoyed a lot of that stuff. In any event, so I decided to apply to the court. I was at a point in my life, early 50s, where I felt like I really needed a change. People told me I was a pretty good jurist, and so I applied, and it took a while, but I very happy that I did. I think in many ways this is probably the best part of my life. But But I think what's really interesting is that I went from becoming a very specialized employment labor lawyer. I did some general health law stuff too, but a very specialized practitioner to a very generalist judge. Because just to, with all the different stuff that I've told you that I've been doing, and I knew none of it when I started. I had no clue about family law. I had no clue about class actions. And I certainly had no clue about Indigenous land title. So it was a great challenge because there's a lot of self-education. Not patting myself on the back, but it's actually true. There was a lot of self-education that one has to do to be able to do this stuff, and it's rare that I go through a week where I'm not doing. I don't have a case with something that I've never seen before, which was certainly not the case after 23, 24 years practicing labor employment law.
I'm sorry I didn't ask that question at the beginning, because I think that would have opened up a whole lot of different questions for us. But I know I'm going to have daggers thrown at me for taking us quite so long here. But I would ask John Donovan, who is our resident lawyer on staff here, to express his feelings and thank you for joining us today. John, can you unmute yourself?
Sorry, *6 to unmute yourself, John.
We've lost John, I don't know. Okay, then tell you what, Rita, if you're there and if you would like to handle this, I know you're not a member, but you're a lawyer also. You might want to step in and do this. Otherwise, you're going to have to leave it to me, and everybody knows that I talk too much.
No, perfect. Thank you so much. Thank you so much, Justice Davis, for your speech. It was very interesting, and we hope to have you among us sometime soon.
Okay.
Thank you.
Thank you.
Thank you very much. As I said, I'm reading that because that was Rita's question at the end about you and wanting to know more about your journey. And I think if I had done that in the very beginning, we would have gone just as long just on that one topic, because I think it's an intriguing thing for somebody to be in a very respected position, and what I personally feel is kind of a rarefied thing. Like we don't know how judges think or how they get there, and we know that they're, and for many people, they're very powerful people. And we might have you back again just to take this a lot more personal.
Yeah, I'd be happy to come back. I think the one thing that you have to try to remember as a judge, and is you're just a person like everybody else. I mean, you're solving some problems that people have, and you have a certain expertise that sometimes they don't have. But we're just a citizen like everybody else. And I think if we can remember that, we're probably better judges, and that's I think we've seen a bit more diversity in some of the recent appointments to the court as well, and I think that's a good thing as well, because we have to be able to relate to the public that we serve, and we're serving the public essentially.
Well, thank you again.
Very welcome. Good night, everybody. Thank you so much.
Good night. Take care of yourself. Next on